I'm confident that I can make a contribution, Chief Justice.
Yes.
Actually, in my first sitting, which was somewhere in October, it was the first sitting, and I was able to produce a judgment, albeit with Judge Victor.
Yes.
Yes. And recently, I've also produced another judgment on my own now. Yes.
How, in comparison to other areas of the law, is this one in terms of complexity?
It's complicated in the sense
How
that
does it compare to other areas of the law in terms of complexity?
it is a specialized area of law.
Yes.
Because you don't look at the law only, you look at the other aspects, for instance, like economics and other aspects of which may, because you're dealing with the issues that we deal with are spread over. You looking at the issue of whether the judgment you're likely to hand down is going to affect the issue of employment, concentration, and other aspects, issue of ownership as well, which is very important, yeah.
I'm not sure I understand. I mean, some people think road accident fund matters are fairly straightforward, but you deal with somewhat complex medical issues there.
Yes, yes.
And all sorts of projections that
Yes.
you must come to grips with.
Yes.
Before you can do justice to those matters. So
Yes.
what is it about competition law that cause it to occupy a particularly special space?
Because you have to factor in the issues of ownership.
Yes.
Yes. One of the key issues that you have to look at is the issue of ownership. The other aspect which is very crucial is the issue of whether what you're trying to achieve is not going to stifle
Yes.
employment and competition as well.
Yes.
Yes.
Now, my experience hearing these cases in the Constitutional Court is that there are very few women, very few black counsel that appear there, and those black counsel that do appear have struck me as being particularly competent
Yes.
in that area.
Yes.
Why is it, if you know, why is it that very few of them appear in the Constitutional Court? Or is it a reflection of their appearances, even in the Competition Appeal Court?
I think so, Chief Justice, but the other issue which I think is very important is the issue of exposure. I don't think they expose enough to the competition law. It seems to be centered around Gauteng and Cape Town. So I think if we can spread over, that could also be of great assistance, yeah.
But there are many women and black counsel in Cape Town and Gauteng. Why is it that those who practice in those areas do not appear to appear in numbers that ought to give one comfort that we're making progress in terms of transformation in that area?
I don't know, except that it's perhaps the exposure, but having said that, in my matter that I've dealt with, where I sat and dealt with, it was comforting to see that there were black advocates. Commissioner, in fact, appeared himself and
Yes.
argued the matter. Yeah.
Any suggestions as to how to facilitate the introduction of women and black practitioners in that area?
I'll perhaps argue that we need to do it through the organized profession and see whether we can be able to reach them, because I think if we do that, we'll be able to.
Yes. Anyway, tell us why should you be recommended for appointment? Just boast a little bit.
Well, I've been a judge, as stated earlier on, for 9 years. I have sat on a number of appeals with my colleagues, and I'm comfortable with that. I'm also a person who's open to persuasion, and I'm also, likewise, if I hold a certain view, I also try to persuade whoever I'm sitting with. But according the respect that whoever I'm sitting with deserves.
Yes.
And I've been, as I said earlier on, I said in my first sitting, I managed to produce a judgment. In my second sitting, I managed to produce a judgment as well. So I think I'm comfortable with the law. I understand it, and I hope to make a difference given an opportunity.
How long ought it to take for those practitioners who were not previously exposed to that area of the law to understand it so that they can practice it? What will it take? How much exposure?
I think it's a difficult question, Chief Justice, to answer, but I think with some training and some exposure on the practical side, I probably think a period of 6 months would be too much.
6 months?
Yes.
Wow.
Or, provided, of course, that the person is willing to learn.
Yes.
Yes.
I thought it takes lesser to expose a lawyer to any area of the law, however complex it might be, before they can have a fair understanding of
I
it.
think it also depends on the individual, Chief Justice.
No.
Yes.
I'm talking about individuals who
Yes.
are willing to learn and are not lazy. 6 months, isn't it too much?
That's why I said it won't be more than 6 months.
Yes.
Yes.
Yes. Very well. Judge President Davis?
I should just add, Chief Justice, we're having a competition seminar for judges in July. We also want to welcome the Constitutional Court to that seminar, if possible. Because what I wanted to ask you, Judge, just explain to the committee, if you may, Commissioner, if you may, you mentioned Professor Fox, the sort
Yes.
of training
Yes.
that you were exposed to in our court.
She is actually part of the people who helped in the drafting of the legislation. And the exposure and the training that I received from her was amazing. And it took us through for the whole week, and I was able to understand the intricacies of the competition law. Yeah.
Can I ask you as well, if I may, your experience being on a collegial court? I remember there was a court, an appeal court.
Yes.
And the question of collegiality.
Yes, I was really humbled to see the way the bench and the defense and the counsel conduct themselves in that court. There is so much mutual respect. I know that the questions that we always put questions, but we always try to be fair and firm to counsel.
Could I ask you as well, I think we can debate the issue, Chief Justice, of course, is correct about the transformation question.
Yes.
But then you've only been on the 2 cases where...
Yes,
Yeah.
yes, I have, yeah.
The second case, you wrote the judgment on your own.
Yes, I offered to
Now-
write
now
the
my
judgment.
place on
yeah.
record, a very good
Yeah.
judgment too, I should
Yes, yeah.
Could I ask you, we're facing a major challenge in our area because the Minister of Economic Development, Minister Patel,
Yes.
has tabled some very far-reaching amendments to the Act.
Yes.
Have you had an opportunity of looking at them at all?
I had a look at them. I think they're quite progressive, the amendment that the minister is suggesting. Because I say this, because if you look at them, they deal with the issue, concentration of ownership. They're hoping to address the imbalances of the past. And also, of what is refreshing in the amendments is that he has introduced a market inquiry which was not in existence before, which will help in going beyond the parties that are before you, beyond the conduct of the 2 parties or the parties that are before you. You actually go beyond. You look at the market as in general. Sorry. Yes.
And could I ask you, on that, do you think it's going to be a challenge for the court? Because the court's obviously going to have to develop the jurisprudence around these far-reaching amendments, that we're going to have to deal not just with conduct
Yes.
of large corporations,
Yes.
but structure.
Yes, you deal with the structure. You look at.
And do you think that's going to be difficult for us to do?
It's going to be difficult, but I always say, where there is a will, there is a way.
But I mean, but just in terms of traditional competition laws only dealt with conduct. That's
Yes.
why I'm asking.
Yes, it's going to be a challenge, but with the assistance of the experts, I think it's going to be possible.
And can I, just one final question. I know you say you didn't do competition law, as it were, beforehand, but before you became a judge, you had, as I understand, quite a distinguished commercial background.
Yes, we dealt commercial matters. Even it, currently, I do preside over commercial matters on appeal and in trials, yeah.
Thank you.
No, thank you, Judge President. I must apologize. A question that I really wanted to ask, or questions escaped me, and I must come back to them.
Yes.
Tell me if I'm wrong. Much of what has been exposed by the Competition Commission as having been done
Yes.
by business is what in the public sector would properly have been characterized as corruption.
Yes, yes.
Why is it that when punishment is visited upon these companies, which at times take what, as you say, could correctly be characterized as corrupt
Yes.
conduct, when punishment has to be visited upon them, there is so much leniency. I'll tell you what I'm talking about. Recently, we had to grapple with a case, I won't mention the case, happily I've forgotten even the citation, from the Competition Appeal Court. Is it the tribunal that comes before it? The tribunal had given a somewhat harsher sanction. But when it came to the Competition Appeal Court, it said, no. This thing is close to the margin and it is not the worst case scenario. And it was reduced, suggesting that there is some sympathy for the corrupt in the private sector, but harshness when it comes to the corrupt in the public sector. How should an ideal judge of the Competition Appeal Court deal with these matters?
Obviously, you've got to deal with it in the context of the facts presented before you. But even more so, it should not be a norm that when you're dealing with the companies, the punishment that you mete out should be too lenient as when you're dealing with, for instance, the corruption arising from the government employees. I think you as a judge, you should try to be as objective as possible and to judge the cases presented before you in a fair manner.
Yes. Now, as a general principle, I agree
Yes.
with you, but let me
Yes.
put it differently. Reflecting on the judgments of that court, did you get a sense that, generally speaking, incidents that border on corruption are visited with appropriately harsh
Yes.
sanctions by the court, as a matter of course?
Yes. No. Definitely.
That's the impression that you
Yes.
got.
Definitely.
What is the maximum that can be visited upon a big company that makes even billions per financial year? What is it?
Generally, looking at 10% of the turnover.
Is it a fixed amount or is it a percentage?
It's a percentage. It's a 10%, if I remember correctly.
And generally, what percentage are judgments where punishment has to be visited upon a company fixed at, more or less, on average?
I haven't looked at the history, unfortunately, but I know that, and I haven't been faced with that situation.
Yes.
Yes. I must be honest with you.
Are you satisfied that that percentage is appropriate, considering that South Africa is a country where we're grappling with corruption in both the private and the public sector? Do those companies get punished with the necessary harshness to demonstrate that whether you are in the public sector or in the private sector, when you embark upon activities that you know to be ethically unacceptable, that either constitute corruption or border on corruption, you will not be allowed to emerge dignified from your acts.
I am certainly not satisfied because my view is this: if the elements of an offence, are there, I should also think there should be criminal prosecution, because to stamp corruption out, because unless you do, you start being serious about that, you never go anywhere.
What percentage would be most appropriate? Is it 10% or should it be taken higher than that, in your view? I know that you'll answer as a judge, not somebody who says, hey, the wind is blowing this way, I need to be considered. You are objective. Is it appropriate or should it be increased, that percentage?
It's difficult for me to, because I'm not presented with certain facts.
No. On average, on the assumption that there would be, in every situation, worst case scenarios, are you saying, in a worst case scenario, say collusion that results in the poor suffering?
Yes.
I would be giving an example, but I don't want to give an example that would point to particular companies.
Yes.
Companies that deal with products, for instance, without which the poorest of the poor cannot survive.
Yes.
And they get involved in these collusions.
Yes.
That would make life even more difficult for the poorest of the poor. Are you satisfied that 10% as the highest punishment is appropriate?
Not Chief Justice, because I'll make an example, for instance, of an issue with the bread issue, because it affects.
I was
the poor.
deliberately avoiding that so that I don't point to any company.
Yeah.
It's best left at the level of principle.
Yes, I'm sorry about that. Yeah, but you balance, the facts, and if for instance, it's affecting the poor of the poorest, then you obviously have to look at a higher percentage, because they have to dig deep to make sure that they cover what they need on a daily basis, to put on the table.
Yes.
And yet there is collusion going behind, which of course, if it had not happened, they were going to be able to get, whatever they wanted to buy cheaper than what they're paying currently.
Yes. Minister?
Yes, just following on the questioning line that the Chief Justice has adopted. I know for a fact that when certain incidents that had happened,
Yes.
Notably around your 2010 period, certain prominent people felt that you can't deal too harshly with certain industries because it would implode the economy, given their size. And I felt I took exception to that because I thought that all are equal before the law. Is that the principle that guides how the competition tribunal or appeal court decides on matters, or are questions of economic impact, given the size of certain corporations, taken into consideration in deciding whether or not and what kind of penalty should be imposed?
It's difficult, Minister, to say, because currently we face with a situation where the law says it's 10%. But, ordinarily, you would want to have evidence to explain the extent of the collusion that we're talking about, and who gets affected, who was affected by it. And in that sense, I would think you would have to judge the case based on what the evidence that has been presented before you. It was difficult because we now dealing with the situation where in law we tied up to 10%.
If I may, Chief Justice. Yes. I'm raising a question of principle.
Yes.
The Constitution in the Equality Clause says that all are equal before the law.
Yes.
So that is an injunction from the Constitution itself. Now I'm asking, in a situation where if that principle were to be applied, that would risk, as others would have urged, whether they're correct or not, the economy as a whole being significantly impacted.
Yes.
Would it be a serious consideration in determining the extent to which the penalty would be meted out against the perpetrator?
It should be, because it has got the far-reaching consequences.
So indeed, it is possible that
Yes.
in a given situation, the very fact of economic impact would
Yes.
be. Okay. And finally, in relation to prosecution, which you alluded to, again, there has been a perception put forward that perhaps, even though there was clear criminality, as a compromise, a fine as opposed to outright prosecution would be a better route to go, because then you're likely to get cooperation and concession, and that would make the job of the state easier in ensuring that justice is carried out. What is your view on those considerations?
I certainly think it's a good thing, because in a way, if you have a situation where a person knows that, or a firm knows that if it engages itself in a particular conduct, it would not only be a question of paying an administration fine, it will also go to an extent of prosecuting them, because I think it's unfair to prosecute public when you can't prosecute private. In a way, it's unfair.
So I'm trying to understand your answer. So you are saying that in all instances where criminality has been established,
Yes.
and certain
It should
individuals,
should be followed by prosecution.
regardless of
Because
the
it would
impact
add.
that would have
Yes.
on the economy. Okay. Thank you very much.
I'm sorry, and tell me, does prosecution follow in these cases?
It's very difficult at this stage because of the way the act is structured.
Yes.
But it will probably, this new amendment has tried
Yes.
to help in that instance. If I remember correctly, section 2 of the proposed amendment, it's trying to deal with the issue of the burden of proof.
Yes.
So
And these plea bargaining possibilities with the possibility of some minimum fine, do they help root out corruption within the private sector?
well,
Just to give a perspective, I'm moving from this perspective. If we are serious about rooting out corruption in this country, and corrupt practices, the tendency to be soft on corrupt business executives and companies should end. Corruption in both the public and the private sector should enjoy maximum publicity. But if you restrain yourself and say, no, it's not appropriate to be hard on corruption in the private sector, you are actually incentivizing corruption in the private sector without realizing it.
it's more so because they know that they'll be able to pay fines and get away with it. That's why I say, if there is that deterrent.
Yes.
Yeah.
Is there a follow-up, Judge President Davis?
Clarify something.
Yeah.
So that we can be on the criminal cartel behavior.
Yes.
You'd agree, I suspect, that there's a difference between what would be called really corrupt practices, such as I think you've mentioned,
Yes.
that bread cartel, and the complexity of Section 4(1)(b), where there may be collusion, but it's a slightly different matter.
Yeah.
Now, the criminal proceedings, we haven't yet got there yet because they haven't been instituted.
Yes,
The act hasn't been triggered.
Yeah.
I just wanted to ask you, that's going to be done by the prosecuting authority, not by the competition
Not by the,
authorities.
by the court. yeah.
People will go to jail for that.
Yes.
Do you think there's a distinction between, on the one hand, correctly putting directors in jail for criminal, well, what are criminal, as the Chief Justice correctly regards as corruption, which it is when you talk about bread,
Yes.
on the one hand, and putting a lot of emphasis on that, whereas if we simply fine, we may put a business out of, we may put the company out of business and jobs get lost, and alternatively, the costs of the fine get eventually redistributed to the consumers. So would you think that it should be our imperative to get the criminal law up and running, which it isn't at the moment?
Yes, that's why I said if there is a lack of will on the part of the criminal side.
Because it hasn't been implemented.
It hasn't been.
Yeah.
And I wasn't sure whether you say it's proper to keep the percentages at 10 or to raise it. Your mic is off. Should it stay at 10% or should it go higher,
Well, depending
in
on
your
the,
view?
depending on the case that has been presented before you, it will
Not,
depend.
not to accommodate the extreme possibilities.
Yes, it should go high because if you make, for instance, billions, for you to pay 10 million, it doesn't really pinch.
Yes.
Yeah.
Advocate Mpofu, JSC.
Thank you very much, CJ. Yeah, I've partly been covered. Would you agree that, okay, maybe let me preface this by saying I practice in this area of law, and I'm
Yeah.
a relative newcomer, 2 or 3 years, but I find it very a significant area of law. For the reason that, as the CJ said, I call it I call the Competition Commission the public protector of
Yes.
capital.
Yes.
In other words, because it's exactly the same issues that you are dealing with there. Obviously,
Yes.
there are nuanced differences.
Yeah.
One of the paradoxes that we have to deal with is that we have what we call a capitalist system or free market system, which is based on the assumption of competition. Competition is one of
Yes.
the big things
Yes.
that gets extolled as part of that system. And yet, it's clear that left to their own devices, big companies will do everything against the public interest and
Yes.
and act in a detrimental fashion. Now, I think one of the issue that I really want to deal with you firstly is the demystification of this area of law, because there's a whole lot of mystery that is built around it. I found, I did economics not as a major at university level, but I was able to understand the concepts very easily. And yet, it's presented as if you have to have a PhD in economics to understand it, which is not true. Because I think this area of law is more about the public interest, protecting the public from the vagaries of the market. And those issues, the constitutional issues, are actually much more prominent than economic formulas and all sorts of flowery things. So what do you think can be done to demystify this area, A, for lawyers, so that, because it's like any other area of law, CJ is right. If you do your first case, second case, and then you get the hang of it, and if you apply yourself, basically you'll be able to practice. At that level, but more importantly, at the level of the public, so that the public can understand that actually the public is not just simply vulnerable to being abused by people simply because they have economic power, and that they have these instruments are available. And sorry to compound the question even more, the issue is not even so much that what the CJ is saying, that but the 10% cap.
Yes.
The issue is that these courts have never even approximated coming to the 10%.
Yes.
So the fines really, CJ, are about 1 to 3%. I mean, this is an unscientific thing. And number one. Number two, the next thing you get told that if there are multiple offenses, it's fine, don't worry, because you're going to kill the golden goose, you're still going to give one fine. And those kinds of niceties don't apply. If I commit 10 counts of corruption, I'll probably be fined or sentenced in respect of each. But somehow there's this nice buddy system. Would you agree that there's at least a perception of that overall leniency and not treating this thing as if it is about protecting the public in the same way as corruption?
Yes, and also just to add on that, I find that it is very difficult for someone, for instance, who stays in a rural area to understand what this kind of court, does. And I personally think there is, the public needs to be educated the importance of the court, because in the same way that they have been educated about the importance of the public protection, so you need to do that. Insofar as the issue of making sure that we see more black lawyers, African lawyers coming up on the fold, I've said earlier on that I personally think through organized profession, we can also make a difference if we go out there and assist and make them understand the importance of this aspect of law.
Commissioner Mpofu, are you done?
No. Okay, practically, what do you think should be done? I accept that we need to do training and all that. But what needs to be done to ensure that the public out there is aware and is able to use the instruments to protect itself against abuse by capital?
I think one has to,
Obviously, I'm talking specifically in relation to the court. There might be many things that the public might do.
Even though we as judges are limited in terms of what we can offer, but I suppose if we educate legal profession about the importance of this aspect of law, and in turn, and rely on them to go out and try to educate the public, that could also be a solution, because we are limited. We can only assist up to a certain point. Yeah.
Right. Okay. The last question, to do with the court itself. Again, another unscientific statistic that I picked up in the streets of the competition law fraternity is that in the court, more than 60% of the judgments are written by the JP. Is that a desirable thing, or should we try and diversify those the viewpoints so that the area is not basically, for the lack of a better word, captured by the same viewpoint, so to speak?
I do understand what the commissioner is saying. I was not aware of that position, but as I said earlier on, when I sat on those two instances, I offered to write and was given an opportunity to write. So there was no hindrances on the part of the presiding
Maybe
judge.
It's the skills base.
Yes, yeah.
All right. Okay. I want to ask you
Yes.
about that judgment you wrote, because
Yeah.
I'm taking it to the Constitutional Court. So I'll be biased here. Thank you, Chief.
Thank you. Commissioner Masuku?
Thank you, Chief Justice. Good afternoon, Judge Mnguni.
Thank you, Mr.
The significance of the court that you wish to join is not, as in my view, has not properly been set out. If you look at the preamble of the Act,
Yes.
it says that apartheid and other discriminatory laws and practices of the past resulted in excessive concentration of ownership and control within the national economy, inadequate restraints against anti-competitive trade practices, and unjust restrictions on full and free participation in the economy by all South Africans. So this court is created in order to create a legal framework in terms of which the economy can be freed
Yes.
in order to advance the economic interests the regulatory interests, or rather, it's really the regulation of how the economy should run.
Yes.
But looking at South Africa as, recently there was a report about South Africa being the most unequal society.
Yes.
Would you say that the court has done enough in order to use the power it has in order to create an environment in terms of which the South African economy and particularly the players in the economy are able to work in such a way that they close these gaps that are created by discriminatory practices and by anti-competitive and unjust restrictions? Do you think that the court has in fact done enough in order to do that? That's the first question. The second question, before you answer the question. The second question, is it not a concern that this court operates only in one province and not in all provinces? And I mean, the judgments that it makes have far-reaching consequences in the whole country, probably affects even international trade. And the fact that it's concentrated only here means that only practitioners within the province have access to that court. Practitioners outside the province don't. No, actually they don't. The only time you get an opportunity to do a competition court matter is when it comes to the appeal in Cape Town. But then Johannesburg advocates are already involved in the matter, so you don't get involved in the case. So I'm concerned that this court's potential has never been really utilized in order to achieve what Commissioner Malema is fighting for in this country, economic freedom.
Yes.
It will not because of the way in which it functions.
Yeah.
So I'd like your comment on that.
Well, just to deal with the second question, the second question relating to the court sitting, I think we have to deal with that aspect through legislation. That's the first point. The second point about the issue of dealing with the issue of ownership, because what it boils down to, what the question that you've asked me, that's precisely when I said the minister has made, proposals, which in my view are progressive, because those proposals or amendments to the Act seek to deal specifically with those issues. The issue of the concentration of economy to a particular, group of people, and they also speak to the to the aspect of dealing with the structure itself, which was not there in the past. Because in the present Act, you can only deal with the collusion. The Act deals with the collusion and market abuse. It doesn't touch on the concentration of ownership, which the minister is proposing now that this court has to deal with that aspect. Which that's the reason why I said earlier on. I personally think it's a very good move, because if we don't do that, we'll never be able to address the imbalances of the past.
Well, thank you, Chief Justice.
Thank you, Commissioner Masuku. Commissioner Nkosi Thomas?
Yeah.
And maybe Commissioner Kane, you could signify whether you still want to come in light of the earlier discussion or not. Okay, then you come in after Commissioner Nkosi Thomas.
Thank you, Chief Justice. Good afternoon, Judge Mnguni.
Good afternoon.
In the questionnaire that you submitted to the Commission, there's a question there, question 16, which asks of you if you have written any judgments and whether of any significance, and it invites you to tell us why those judgments are deemed to be significant by yourself. So you listed 11 judgments there.
Yes.
One of them being the matter of Hoskin Consolidated. It appears to be the one that pertains, that is relevant
Yes.
to this application.
Yes.
But what you have not told us in this questionnaire is why you regard this particular judgment to be important or significant. Are you able to enlighten us as to why
Yes,
you
I'm sorry
considered it to be of some significance?
I'm sorry.
I
I'm sorry
raised the
about
question
that.
because
Yes.
it is relevant
Yes,
to
yes,
this
it is,
application.
yes. I'm sorry about that, and it is significant in the sense that if you consider the new amendment, especially section 12B, that section deals specifically with the lacuna, which the proposed amendment is seeking to address, and that judgment is relevant because after that judgment, the lacuna was exposed and the legislation has been now is proposed to deal with at that aspect. I'm sorry that I didn't mention it, yes. But if you look at section 12B of the proposed amendments, it deals specifically with that case. Yeah.
Very well, thank you. And I
Yes.
think it's the GCB that commented at length about the judgment, and you co-wrote with AJA Victor, am I right?
Yes, yes.
And yeah, it appears as though you did a very good job there.
Yes, thank you very much.
Well, is it on appeal? Yeah, but you're not being criticized. That's what the GCB is
Yes.
not criticizing the
Yes,
judgment.
yes,
That's all I'm saying.
yes,
Thank you. Thanks, Chief Justice.
Thank you, Commissioner Nkosi Thomas. Commissioner Kane?
Thank you, Chief Justice. Good afternoon, Judge.
Good
I'd
afternoon.
like to pick up on the discussion that was being held with you just prior to Commissioner Nkosi Thomas proposing her questions. And it pertained to something the Judge President raised and that my fellow commissioners on both sides of me took further with you, which was the structural issues
Yes.
in the proposed amendments to the Competition
Yes.
Act. Now, as I understand your answer, you said that you considered that you would be in a position to deal with those issues if you
Yes.
were appointed to this court with the assistance of experts.
Yes.
Could you take that a bit further and just explain to the Commission how experts' evidence will be considered? And I just refer to the recent criticism of the Competition Appeal Court, in
Yes.
which the role of experts in opining on legal trust issues was taken up. And I do understand that the line between expert evidence on law and economics is a very blurred one in the
Yes.
competition arena. But I'd like just to understand how you would approach these difficult questions if you called upon as a court to deal with structural issues.
But you see, with structural issues, it involves investigation. That's the first thing, which is to be done by the authorities, the competition authorities. So in other words, it's evidence-based. You have to have evidence. And when you make a decision, you make a decision measured on the evidence that has been presented before you. So in essence, you can't on your own come up with your own ideas without, especially those ideas don't speak to the evidence that has been presented before you. It is in that context that I say will be helped by the expert. I know, of course, the role of the expert in the civil proceedings.
Yes.
Yeah.
Thank you very much for that answer. May I take up one other issue with you just to understand your approach
Yes.
in these kinds of difficult questions? My understanding is that Section 4 of the Competition Act makes certain conduct or agreements between competitors a violation
Yes.
of the Act, and I think that will remain so under the new amendments. When you have a vertical agreement that has a horizontal
Yes.
dimension, if you were to be confronted with such an issue, would there be any room for holding that it doesn't contravene the absolute prohibition in Section 4? How would you deal with that issue?
It's a very difficult question to answer, I must say, because, as I said, it should be evidence-based. I mean, I can't really make a pronouncement in abstract. I have to have evidence before me, before I make that pronouncement.
Well, may I ask you this? Is there room for any kind of horizontal dimension or agreement that, between competitors when you have an overlap between vertical and horizontal
I thought that is
relationships?
prohibited in terms of the Act.
And when there's a blurring in the relationships, because you could have a situation where there's a vertical relationship that has a horizontal dimension.
I don't understand what the commissioner is trying to ask of me. I honestly don't understand the
All
question.
right, perhaps I'm not clear enough and it's
Yes,
not my
I
area
really
of
don't
expertise, so
understand.
the fault may
Yes.
lie with me and I leave it to others who know more
Yes,
about the
yes,
field
yes, thank you.
to take it further then.
Well, maybe I can assist. This is a
If you
question.
could switch off the other mic,
Oh, yes.
Advocate, thank you.
Thank you. I was saying there is an issue over which the judge president and I had a small debate last week in court.
We had a big debate, but we haven't decided the case. So
Yes.
neither you
So-
nor
so-
I are going to say any more about it.
Yes, I do. No, I think what Commissioner Kane is talking about is the situation where it so happens that the horizontality or verticality of the
Yes.
relationship is an issue.
Yes.
And that was dealt with, for example, I think in the SAB case.
Yes.
Whether in those kinds of cases, and this is what we were debating in court last week, is there room for what is called the characterization test? In other words, to use it to even determine whether the relationship is predominantly horizontal or vertical.
In the present context?
Yes,
or-
in
because
the-
not in the present, but in
Yes.
in
No.
the proposed amendment, there's definitely.
Yes, but the bigger
yes.
question is
Yes.
this. Remember that section 41B of the Act is meant to bring what I call strict liability.
Yes.
In other words, there should be
There
no
should be.
defense, no justification.
Yeah.
And the issue that we're debating is whether using the characterization issue isn't introducing a defense to something which is supposed to have no defense through the back door, so to speak. Can you comment on that?
It's difficult for me to comment because as far as I know, if you're trying to introduce something, in terms of the new act, of the act is currently, I don't think there is, as I said, there is. But in terms of the proposed amendment, there's definitely a room to deal with that aspect. Yeah.
Thank you.
Yeah.
You want to rejoin Advocate Kane?
Thank you, Chief Justice. If I may canvass one more area with you, Judge, it pertains to predatory pricing in Section 8D of the Competition Act. And I'd like you to explain to the Commission how you would approach the issue of cost standards and whether intention would have any role to play in deciding a case pertaining to cost standards.
You mean the cost in relation to the outcome of the case, or what cost are you talking about?
I'm talking about the issues of marginal cost and average variable cost as described in Section 8.
Yes.
And the issue of a dominant firm charging
Yes.
prices below.
At a reduced
Cost.
price, yes,
Yes.
yes,
At a price.
yes. You mean how do you approach that?
Yes, what is the guidance or how would you approach such a case?
But
What
obviously,
principles?
the first step is to have facts before you, and those facts will lead you to a certain conclusion. It's difficult to say, this is the approach which I'm going to adopt without being presented with the facts, the evidence, the hard evidence. That's the only way you can deal with it. Because for you to be able to determine whether there was a reduction, unreasonable reduction of the price, we have to look of the price, we have to look at the evidence presented.
Yes, I was really just asking you as a judge of the Competition Appeal Court what legal principles you would bring to bear.
I can't pass judgment on something that is not held before me, unfortunately. Yes.
Very well. Thank you, Chief Justice.
If you could switch off the mic, Advocate Kane, thank you. Judge Mnguni, I'm sorry to have to come back. I'm worried about this because it's a very important court, this one. You see, anything that is made difficult to understand to use the words of Advocate Mpofu SC, mystified,
Yes.
tends to leave a lot of room for manipulation and even corrupt activities to be perpetuated without effective detection. And I'm one of those who believe that if there is anything that has the possibility to demystify any concept, it is the law. And I was gratified to learn from the Vice Chancellor of University of Johannesburg, and I think one of the geniuses, scientists who died recently, that actually even science can be explained to the point that anybody, educated or uneducated, can understand it. Now, one of the challenges with this competition law area, and tell me if my understanding is wrong or not, from the Competition Commission, the tribunal, all the way through to the court, the regulatory framework is structured in such a way as to make it unnecessarily complex, unnecessarily difficult for people to grasp it, and therefore creating the possibility for corrupt activities to elude the system, with the result that effective arrest of these undesirable and yet economically toxic tendencies, as far as the poorest of the poor are concerned, to continue. What is it that needs to be done? I'm coming back to Advocate Mpofu SC's question. To demystify this area of the law and its practice, to facilitate detection of wrongdoing, to facilitate the attainment of the objectives set out in the preamble. What is it that needs to be done?
Yes,
Because for as long as it's so a highly intellectual, people get away with murder in codes.
yes, no, I agree with you, Chief Justice. But as I said earlier on, I don't think we have done enough to educate the people, the legal profession about this aspect of the law.
About educating them, or is it about doing something about even the law as it stands? I mean, sometimes you come across strange formulas. It's a struggle to, what are they saying now? And before you know it, there is some conclusion which doesn't quite register as sensible that is being arrived at. Because there is, I don't know whether it's a question of just taking what others are doing elsewhere and applying it to South Africa, even if it doesn't quite help, or why is it that it's made so intricate, so difficult? Shouldn't something be done about this complexity in codes?
I personally think there should be, but I even offer myself to help in that regard if there is any need to. I personally think there is a need to educate the public about it.
Yes. So you think it's more about education than the regulatory framework itself?
Because as far as I can see it, the public is not even aware of
No,
this.
but I'm not talking about the
Yes,
public.
yes.
I'm saying for the Competition Commission to be effective and all the structures created to arrest this sugar-coated corruption, because sometimes it is, you need to do something about the regulations and the act
Yes.
before you can even teach people.
Whereas they-
Make it user-friendly. Is that not the
Yes.
problem?
That's
And
the problem, and the transparency as well.
Yes,
Yeah.
yes. Anyway, thank you very much, Judge. You're excused.
Thank you very much.